First thing is, I think from us, just to say thank you to all of you for joining us both in the room and online. I'm a partner at UK and a Downs expert with a particular background in energy and infrastructure. As you can see, we've got a panel today. So to keep us moving forward quickly, I'll keep introductory remarks very brief, and also the panel intros, but you will get this circulated afterwards for more detail on all of the members of the panel. If I briefly go through who's actually on the panel, we have Amy Armitage, who's a counsel at Norton Rose Fulbright, in terms of practice of disputes management, as well as dispute resolution in the context of construction and engineering disputes, has a master's degree in construction law and arbitration. Then if I move on to George, as a barrister, George Swarton Casey, as a barrister for New Square, so specialised in heavyweight commercial litigation and international arbitration, also sitting as an arbitrator in cross-border disputes. Moving on next to Catherine Dodson. Catherine is barrister at 39 Essex Chambers, specialising in environmental law, and has acted in some of the leading environmental cases in recent years, acting for Friends of the Earth in the successful challenge to the government's net zero strategy, and for a coalition of claimants in the challenge to the government's decision to support a third runway at Heathrow Airport. Moving next to Holly. Holly Stebbing is a partner in Norton Rose Fulbright, and a commercial litigation and dispute resolution lawyer, with a practice focusing on disputes in energy, infrastructure and natural resources, and has a master's degree in energy and natural resources law, as well as being on the committee of the Energy Arbitration Club and one of the contributing editors to getting the deal through in energy disputes. And then finally on this list, my colleague Alex Lee, sorry, no, not finally on this list, I should talk carefully, that's what I'm doing. Adrian Barnes is with us from the Green Investment Group. He's head of green analytics there and is responsible for the implementation of their robust green assessment, monitoring and reporting approach. He's a chartered environmentalist and fellow of the Institute for Environmental Management and Assessment, and with a background in environmental consultancy, and also represents Green Investment Group on standardization initiatives for technical green assessment. And now I'll come to Alex. Alex Lee, my colleague, who's a chartered geologist and scientist with over 25 years of experience. He's been appointed as a technical expert on more than 20 occasions and acts on as an expert for environmental matters, including contamination, risk assessment, and remediation. So, with that, forgive me that it's a whistle-stop tour, but at least people have an idea of who's in front of them. What we're going to do is start by setting the scene in terms of where the claims are coming from, which Amy will lead. Then we'll dive into some of the practical issues arising, particularly from a corporate perspective. And Adrian will look from the perspective of their investee companies at how these matters are taken into account. We'll move on to look at the UK side of this in terms of both how jurisdiction is being established here, covered by George, and the developments with attribution for Scope 3 emissions. For anybody who's not familiar with that, will be explained, which Catherine will address. Panning out then to the international perspective, looking at the investment treaties and their role, climate litigation from Holly, before rounding off with insight from Alex on the climate science developments, and I will cover some of the changes in valuation approaches for ESG issues. So like I said, it's a pretty packed panel, so we'll keep moving straight away. And with that, I'll pass across to Amy.
Thanks, Colin. So in terms of where these claims are coming from, so in the past 15 years, we've seen a new class of disputes emerge in relation to ESG and climate change. These are strategic claims deployed by claimants to either compel governments to do more in respect of climate change or to seek compensation in respect of damage that's been caused by climate change. This is very much an international phenomenon, although there are particular hotspots, for example, in the US, Australia, France, Netherlands, but also the UK. And in the first wave of these claims, the states are very much the target. So we saw individuals and NGOs bringing actions to compel governments to adhere to their Paris Agreement commitments. But now we are seeing a sort of second wave of claims targeting corporates, not just energy companies, the sort of high emitters, but also the financial institutions that sit behind them. And I think one of the challenges for advisors is really just the myriad of international, national and soft laws that these claims encompass. Claimants are becoming more and more creative. We're seeing novel causes of action being tested in different forums. But it's also just the broad sort of categories of law that we're seeing. So you could be dealing with anything from sort of constitutional, human rights, environmental planning, tortious, contractual, etc. And I think it's fair to say that, you know, typically these claims are fraught with legal challenges, whether that be causation, justiciability, attribution, etc. But yet, despite the legal barriers, we are seeing a steady rise of climate cases. I think since 2015, these cases have doubled. I think we're over 2,000 sort of climate cases globally now, a quarter of which were filed between 2020 and 2022. And I think one of the reasons we are seeing this steady growth in climate cases in particular is that success is not necessarily predicated upon a successful judgment. So claimants will often see value in the steps that a government or a corporate may take in response to the litigation. So the changed behaviours that are brought about, whether that will be sort of taking further steps to reduce emissions or greening up a supply chain. And there's also of course the negative publicity. So the reputational damage that could be suffered by a corporate, even if the claimants are unsuccessful, and they often are. So in terms of 2023, I think this promises to be a landmark year. We're seeing a growth in the number of cases and the diversity of cases in the forums in which these cases are being tested. We've got a number of first of their kind cases coming through the courts and some key judgments later this year. So I think this is certainly an area that's getting hotter, and one which I'm sure we'll all be watching with keen interest over the next 12 months.
Thank you very much. Thanks, Amy. And if we move straight on then to Adrian, we give the corporate perspective on some of this.
Thank you, Colin. I think it's very interesting to hear about Amy's point there on the point about the success of the case not resulting necessarily on the judgment, because looking at it from the corporate perspective, they are very concerned not only about not being tied up in lengthy disputes, but that reputational perspective I think is core in terms of attracting investment. They are operating in a universe where there is a vast amount of capital available earmarked for companies that meet environmental, social and governance criteria. And those can be framed in various ways, but there's a strong correlation, I guess, in valuation between companies that have a strong and robust, future-proofed approach to managing their ESG risks and opportunities. In some cases, that's being forced by legislation. The implementation of mandatory climate risk reporting and transition risk reporting against the TCFD, Task Force for Climate-Related Financial Disclosures regulations, but also in a broader sense, that it's increasingly seen as a hallmark of the valuation and robustness of a business, that it has a strong approach to its governance and its handling of environmental and social matters, and therefore being faced with either action from regulators or claims through litigation is something that can end up affecting the valuation of an investee company almost far more than the actual value of the claims that are being considered.
Excellent, thank you. So, George, take us into the territory of jurisdiction.
This is where it gets really exciting. I'm going to talk about ESG, particularly in the domestic context, talking about it from the perspective of UK lawyers, really. And in that regard, these claims can, of course, be approached in a number of different ways. Parent companies facing liability as a result of the conduct of subsidiaries abroad. We'll come back to that in a moment, because that's really seen most of the action. Perspective of insurers in England who might be liable for the conduct or misconduct of their policyholders around the world. Or indeed, one can look at it from the regulatory perspective. One can also approach it by reference to the causes of action: common law, nuisance, tort of negligence, claims against directors, increasingly being seen around the world, derivative actions, or in this jurisdiction, section 172 of the Companies Act has been deployed recently, and claims, of course, for breach of fiduciary duty. So a range of different categories of claim, a range of ways of getting the claim into the courts in this jurisdiction. The bottom line, as Amy has said, is that these claims are now very much on the menu in the purely civil context, in the way that they simply weren't 5 years ago, let alone 10 years ago. So in that overriding context, I'm going to focus a little more on the parent company aspect of all of this, touching on 3 authorities that I suspect you will have either heard of or be familiar with: the Vedanta case, Shell, and then BHP. And indeed, it's possible 1 or 2 people here might have been involved. And if I'm right about that, put your hands up at the end, and please do feel free to comment when we've finished our sections. But hopefully, even if they are familiar to you, it'll provide context for the rest of the talks this afternoon. So, first of all, Vedanta. Well, Vedanta involves a claim by Zambian claimants concerning discharges from a copper mine owned by Vedanta's Zambian subsidiary, KCM, which allegedly caused damage to the land of the Zambian claimants. The main issue in establishing jurisdiction was the extent to which the parent company, domiciled in London, could be said to owe a duty of care to the claimants, and made its way up to the Supreme Court. And given we're doing short sections today, I'm going to provide an overview of each of these cases, and we can always revisit them later. But in a nutshell, what's interesting about this case, albeit at the jurisdictional stage, is that the Supreme Court adopted a generous approach to the question of parent company liability. They recognise that it's not just a case of looking at a menu of prescribed factors and then sort of going through a tick box exercise. Indeed, for example, the extent to which a parent company might be said to have controlled the subsidiary is merely one factor of a number to be taken into account. So if you are running a FTSE 100 company in London, you can't simply say, oh, well, look, there's a separate subsidiary elsewhere in Zambia. There are all sorts of factors the court will look at. And they include whether or not the parent company has got group-wide policies. Is the parent company sending out material implying that it has got a measure of control, rightly or wrongly, over its subsidiary elsewhere in the world? Is that one of its selling points to investors, international investors, in terms of its location in the London market? What about training? People from the subsidiary come over to London for training on these type of issues. And what about, say, the extent to which a company has held itself out as being responsible, even if that's not the case? So the Supreme Court was prepared to adopt a really broad approach to that question. And that, as I say, the first of the 3 big recent decisions, with the second being Opabi and Shell. Opabi and Shell concerns claims by Nigerian claimants alleging that Shell, as the parent company of the Nigerian subsidiary, Shell Petroleum Development Company, and the allegation is that it owed obligations as a result of, in that case, oil leaks from pipelines in infrastructure in the oil extraction industry. Again, this is a decision at the interlocutory stage. So we're not talking about the final decision, as I'm sure you're aware. Nevertheless, it's really instructive to see the way the Supreme Court approached it, essentially doubling down on the Vedanta decision, and recognizing not only was it arguable that the parent company might owe obligations to the Nigerian claimants, but going further in some of the comments about the relevance of control in that particular context. Considering, for example, whether the parent company or individuals employed by the parent company might have exercised de facto control over parts of the subsidiary. One particularly striking aspect of that case, though, going beyond those factors, the parent company relationship, was the approach to factual issues that might eventuate a trial. Because this was an interim stage hearing, the court was asked to reflect on the extent to which factual matters might develop by the time the claim came to trial. And one of the really, I think, significant observations of the Supreme Court was the fact that the internal documents of the parent company, going back a number of years, was said would have obvious importance to the potential outcome of this dispute. And whilst that might strike us as a sort of fairly obvious point in and of itself, that disclosure may be relevant, it was the extent to which the Supreme Court were prepared to engage with what was going to be a wide-ranging disclosure exercise going back over a number of years, imposing that on the parent company in the context of this particular relationship, with obvious ramifications for companies domiciled in this jurisdiction. So you start with the Vedanta decision, you then see in Shell, Supreme Court really emphasizing the extent to which these claims can be brought in this jurisdiction, but also indicating a real willingness to entertain fairly broad disclosure exercises in support of this type of claim. The third of the claims is that's ongoing is the Mariana and BHP case. That's a case involving, let's say, BHP, the Anglo-Australian mining entity. It indicates a slight development of jurisprudence, because it's not just parent company's relationship with subsidiary, but also the parent company's potential liability for the subsidiary's role in a JV that was said to have been responsible for the Fundão Dam disaster in 2015 in Brazil. Now, whilst, again, what we're looking at an early stage, it was issues particularly focused on abuse of process and the extent to which remedies in this jurisdiction might overlap with the remedies in Brazil. It's again striking that in this case, Court of Appeals hasn't yet got the Supreme Court. The Court of Appeal was willing to entertain the claim and emphasizing the importance in that case of providing access to a fair trial in this jurisdiction for the claimants. So in summary, a real sense of willingness across these claims from the UK courts who allow claimants to bring claims against a parent company in that particular context. And of course, it's not just parent companies. One can see this extending to private equity investors, the banks that have potentially been involved. It's not a big leap to go from these cases to a whole range of other cases. And by way of a final observation, one sees that with the Braskem case in the Netherlands. People are familiar with that case, but there it's the subsidiary that is domiciled in the Netherlands that's facing the claim, not the parent company. And the argument's been run, it's been allowed through by the District Court of Rotterdam fairly recently, is that group level decisions are being taken by the subsidiary, therefore allowing the claimants to bring the claim in that jurisdiction. So it's not just a case of saying, oh, well, we've got a parent company in London, we can bring the claim there. You need to look at where decisions are being taken, including by subsidiaries. So now I'm going to hand over to Catherine, I think.
Yeah, thank you, George. So sticking at the domestic level, I want to highlight the move towards requirements on corporations and companies to assess and account for their Scope 3 emissions. And I'm going to talk about two cases that are currently going through the English courts where that is a live issue. So for those who aren't familiar with the terminology, Scope 3 emissions are emissions associated with inputs and outputs by companies further up or down the supply or value chain. So, for example, for a car manufacturer, Scope 3 emissions would include the emissions produced by customers driving cars. Scope 3 emissions would also include the emissions produced through the production of electricity that a company buys in for its use. So, Scope 3 emissions. Now, currently, the UK government's environmental reporting guidelines do not require companies to report on their Scope 3 emissions. But as part of the Green Finance Strategy published in March this year, the government announced a consultation on reporting Scope 3 emissions. It's going to look at the costs and value to companies of expanding the obligation to include reporting for Scope 3 emissions. So that's something to keep an eye on. On the litigation side, as I mentioned, there are two cases currently going through the English courts where it's been argued by one of the parties that there is an obligation to assess Scope 3 emissions that may be found within existing legal regimes. So I'm going to talk a little bit about those two cases. The first case is Finch and Surrey County Council. This involves a challenge to the grant of a planning permission for the expansion of a commercial crude oil extraction project. And the issue in that case is whether the environmental impact assessment should have included assessment of the Scope 3 emissions of that project. So the Scope 3 emissions there would be the emissions from the end use of the oil extracted by customers. The Court of Appeal held that this depends on whether or not combustion of oil by end users constitutes an indirect effect of the project for the purposes of the EIA regulations. And the Court of Appeal has held that that is a question of fact and evaluative judgment for the planning authority. What they've held on the facts in that case is that it was reasonable for the planning authority to conclude the combustion of or end use of the oil extracted is not an indirect effect of the project as it's too far removed. So they said the intervening processes that the oil extracted would have to go through, like the refinement process, meant that it wasn't an indirect effect. But I think critically, in terms of the longer term significance of this case, the Court of Appeal did not find that it could not lawfully be an indirect effect. It's a question of fact and judgment for, in that case, the planning authority. So it could be that planning authorities conclude that Scope 3 emissions should be included in environmental impact assessments. So the Finch case is going to the Supreme Court. It's going to be heard next month. So something to look out for how they approach that issue. The second case where Scope 3 emissions are a live issue is a challenge brought by Friends of the Earth to a decision of the UK government to provide export finance to a liquefied natural gas facility off the coast of Mozambique. So there are a number of issues that have been raised in that case, including the approach to interpretation of the Paris Agreement and the correct interpretation of the Paris Agreement as a matter of law. But for these purposes, a central part of the challenge brought by Friends of the Earth is that they argue that there was an insufficient evidentiary basis for the UK government to conclude that funding this project was consistent with the UK government's obligations under the Paris Agreement. And they said that the fact that there hadn't been a quantified assessment of the Scope 3 emissions of the project meant that the government simply didn't have the information to determine whether the funding and the project would be consistent with the obligations under Paris. The Court of Appeal rejected that argument, but not on the basis that Scope 3 emissions are irrelevant to that assessment. They rejected the argument on the basis that the government had been told that Scope 3 emissions would dwarf scope 1 and scope 2 emissions. So they had sufficient information about the scale of scope 3 emissions to form a view on compliance with Paris. So in that case, Friends of the Earth has sought permission to appeal to the Supreme Court. A permission decision is awaited, but again, we may hear further on that if permission is granted. Both of these decisions in quite different legal contexts, one a planning decision, another a public law decision about export finance. What you see is parties arguing that there's an obligation on the government or a public body to evaluate or to require an evaluation of scope 3 emissions in order to determine whether they can support a project, in order to take that information into account as a material consideration as part of its decision. So I think it is a part of a trend that parties are arguing that scope 3 emissions are relevant material factors in public body decision making. So watch this space. And I do have a couple of questions for which maybe Adrian and Alex could pick up on. For Alex, from the environmental science perspective, in both of these cases, it was discussed whether or not it was actually feasible to assess the scope 3 emissions of these projects. And I think it was put in the 2 difficult boxes, and everyone agreed to proceed on the assumption that you could assess these scope 3 emissions. It'd be interesting to hear from you how easy it is in practice to carry out that assessment.
It's the exciting science bit now, so I'm the odd one in the room here, I think, as the environmental scientist. So first of all, scope 3 emissions. Is it possible to measure scope 3 emissions? The answer is yes. Is it always going to be easy to measure scope 3 emissions? The answer is not always. It's obviously going to depend on the product and the supply chain, etc. But scope 3 emissions aren't trivial. I think the Carbon Disclosure Project last year declared that some 75% of many enterprises' emissions are actually scope 3. And in some organizations, it's up to 100%. So ignoring scope 3 emissions in decision making is actually quite a fundamental component of it. And it would actually trivialize our aspirations to become carbon neutral, etc. If you look at things like the science-based initiatives, etc., the zero carbon initiatives, you can see, for example, the next 5 to 10 years, those organizations that have signed up to a science-based target for net zero, they've got to report, I think, 67% of their scope 3 emissions within the next 5 to 10 years and 95% within the next, by 2050. So this is a big issue, and it's not a trivial issue, and it's not going to go away. But the interesting thing about it is that the Greenhouse Gas Protocol quite some time ago identified ways of measuring scope 3 emissions, albeit quite crudely. And they identified 15 types of different categories of scope 3 emissions, 1 to 8 upstream, 9 to 15 downstream. And for example, in the Finch case, item number 11 is the emissions for the products that you actually sell, for example, the oil, the fuel, etc., etc. So this is going to become quite an important issue. But the difficulty is it's burdensome, and there's the potential, and people are turning around and saying, well, this could result in litigation. In other words, if I've committed to this and then I fail to deliver this, could I suddenly find myself in court by activist organizations, etc.? But the interesting thing for me to put my science hat on is that actually, wherever I'm modeling the London Eye there or that crane over there, there's a series of principles in any form of mathematical modeling or environmental modeling. And it's all about management of uncertainty. And scientists are very good at dealing with uncertainty. And courts are good at dealing with probability and uncertainty as well. And what's actually happening at the moment is when we're looking at, for example, scope 3 emissions or scope 1 or 2 emissions, we're doing it in a very deterministic way. A equals times by B equals C. So the problem actually is whatever you put in that model, rubbish data in equals rubbish data out. And a lot of the time, we might know what A is. We might know what B is. A might be a range of numbers. So we have data uncertainty. It's one of the biggest forms of uncertainty in any model. We might not know in our supply chain the carbon footprint. It might be an estimate of an estimate. Our supply chain might not even want to share the carbon footprint of their product, etc. So what numbers do we actually put into the model? But from a scientific perspective, I accept the fact that we've got a range of numbers, so I put them all in the model. And I do it probabilistically. I use Monte Carlo simulations, etc. and I put the full range of parameters into the model to generate, for example, 1,000 simulations, and I take the 95th percentile result of it. So in other words, I deal with that uncertainty mathematically, accepting, for example, that there's going to be uncertainty in them parameters. The next kind of uncertainty, which actually came up in the Mozambique case, the LNG case, is conceptual uncertainty. So when I'm delivering a model, or I'm delivering a number, do I really understand what that model is going to be based on? I'm actually modeling the right thing. So in the Mozambique case, one of the issues there, and I'm not close to it, so do correct me if I'm wrong on this, was actually they don't actually know, or didn't know, how to offset those numbers. They were going to have a certain carbon footprint, but also they're going to be able to offset some of those numbers associated with substituting some of those energy supplies with more cleaner energy supplies. But that's dependent upon future trade agreements, which aren't in their control. You don't know when they're going to happen or how it's going to happen. So there's a huge load of conceptual uncertainty. Again, from a scientific perspective, we can manage that. We can manage it by scenario modeling. So what we do is we get envelopes of uncertainty to help us make informed decision making. We then have the final one, which is model uncertainty. Now, I'm not saying you do this on every job, but fundamentally, model uncertainty is, am I even...
Sorry to interrupt, but we're having trouble hearing you here in the middle, so
okay.
what it's like for the people in the back.
Are you guys at the back there okay? It was really interesting, by the way, though. Can everybody at the back hear me? Can somebody give me a hand? Just, okay, I'll tell you what I'll do. Oh, well, there we go. I am a bit croaky today as well, so unfortunately the cable's not very long. So the final source of uncertainty is model uncertainty. And model uncertainty is, are we actually modeling? Is my model actually going to reproduce what I want it to reproduce? Now, the way around that actually is to use lots of different models and try and calibrate and validate them. And you use that a lot in attribution modeling. Now, I'm not saying that actually everybody doing scope 3 emissions should go to this incredible scientific piece of exercise of probabilistic modeling, etc. But fundamentally, if your business is dependent upon this, if your sustainability linked loans, if your application for planning is highly dependent upon the requirement to understand scope 3 emissions, then like any other part of your business, you apply the appropriate level of due diligence with the right expert to understand what that envelope of uncertainty is and report it. Now, the interesting thing about the Finch case, and I stole this from Catherine, she sent me this earlier on. In the Finch case, the question was, is it scientifically possible to calculate a theoretical level of greenhouse gas emissions? And then later on, it's about general estimates. Nobody's actually saying we want precise numbers. The ISSB and what else was it last year? ISSB and SSAB last year identified that actually when we're generating scope 3 emissions, they're never going to be really certain. So they've actually put in place a safe harbour. They unanimously voted for a safe harbour on these decisions last year. So what we're actually trying to do is show transparency in the generation and understanding, so we can, have informed decision making. It's not about necessarily about precision. Nobody's asking you for precision. It's about informed order of magnitude. So in answer to Catherine's question, yes, we can do scope 3 calculations. Yes, it's not always going to be easy, but it's proportionate to the question on the table. If this is a big decision-making question, you need to get the right expert on board and put the right amount of due diligence and effort into it. And that might involve probabilistic modeling. It might involve using more than one model, but it can be done. Does that answer the question?
It does. Thank you.
Thank you. Apologies for the people at the back, but it was really interesting, particularly at the beginning.
If we've got time to follow up with Adrian, I just wanted to ask Adrian, you mentioned in your contribution that it's you're evaluating risk associated with future investment. To what extent are you including scope 3 emissions as part of your evaluation of investments?
So there's various contexts in which scope 3 emissions come into play from a sort of financial perspective, and just sorry to respond to Alex's comment, I think I'd class myself as an environmental scientist as well, so there's at least two of us in the room. And actually following up on that point, is it possible to evaluate scope 3 emissions? Definitely agree with everything Alex has said. I'd just maybe add to that, if you ask the question, is it possible to evidence that you've done it correctly? That you have arrived at a result that is correct? I would probably say no in theory, because that really depends on where you draw your limitation of scope 3. How far up and down that value chain you go is fundamentally a question of two factors in terms of the degree of control you have over it and the degree of materiality it has. So when we're looking at when we're looking at a given investment into an asset, we will apply those tests of materiality and control in a very focused way. So, for example, if I take an onshore wind farm that has effectively virtually zero scope 1 emissions, zero scope 2 emissions. So the scope 3 emissions are the most material aspect of the emissions associated with that project. It has as an asset owner, you have varying degrees over control of those scope 3 emissions. So if you think about the emissions that went into producing the steel that made the tower that goes into your turbine, you can make a procurement decision that says we will preferentially source our turbines from suppliers, from manufacturers that can evidence a lower carbon supply chain. Does that mean you have control over the individual steel mill the steel came from? Well, probably not, but you should still factor that into account in your decision making. But I guess sort of coming right back down to the first point I mentioned, the lens through which you're looking at is very important. So if you're looking at through the lens of net zero claims and net zero alignment, it's sort of, I think, broadly accepted that net zero as a concept can't really include scope 3 from an accounting perspective because of the degree of overlap between institutions. When you're doing accounting, you have to look at the emissions that are accounted for by, if you're doing a corporate emissions accounting or financed emissions accounting using the PCAF methodology, there will always be overlap between scope 3 emissions. So you could never really reach net zero if you accounted for all of your scope 3 emissions, because by definition you would be saying, well, we will not only offset all of our emissions but all of the emissions in our supply chain, and you extend that, you know, throughout every corporation in the world and every actor in the world, and you get mass overlap of trying to account for those emissions. But there are other degrees in which you very much have to do it. So you know, if you take things like alignment to other commitments, alignment to things like the EU taxonomy for environmentally sustainable activities, there are clear thresholds set there. Bioenergy is a clear case in this point, where to declare an activity as eligible under the EU taxonomy, you need to meet a certain threshold of carbon intensity, and that is including for scope 3 emissions. So it depends. The sort of tricky answer is it depends. And what you really need to do, because your scope 3 accounting is very much the reliability of that is contingent on the parameters you set around it, is make sure you have very clear disclosure on what assumptions you've made, what you've included within your scope 3 accounting, and to a certain extent, you know, the markets then decide whether you've done that right or wrong.
Just to reinforce that, I think it's all about uncertainty analysis, sensitivity reporting, and transparency. You don't necessarily have to have a precise number, as long as you've been very clear on the assumptions and where you've drawn the line and what your model's sensitive to. So if you know that your model is sensitive to a given parameter, that's work in progress. You know that's where your focus has got to be. It's got to be. And the reason for delivering these numbers as well is not just about a due diligence exercise. It's actually about trying to drive behavioural change. So by doing that exercise and understanding where the transparency and the gaps are, you're providing an opportunity for you to then focus next year or the year after to get those numbers down. So you've got to think also about what is actually the question being asked, which is a big thing. You know, it's not just a due diligence exercise, it's about behavioural change. So the banks, the investors aren't going to come after you aggressively for not knowing everything. They don't expect you to know everything. They expect you to basically understand where the gaps are, understand what the weaknesses are, understand where you're going to focus. And that's what Adrian's world is.
So, having given all of the challenges that are facing measurement, challenges on jurisdiction just domestically, probably take us into the world of the investment treaty.
Thanks, Colin, and hi, everyone. I'm sure I don't need to tell you that one characteristic of energy projects is their very high upfront capital costs and the risks that are involved in the oil and gas space, whether your exploration will find anything and lead to production, in the renewable energy space, whether untried technology will come off or not. And to mitigate this, states look for overseas investment, private investment, to help develop critical national infrastructure. But once a project is up and running, money starts to flow. There's the risk that states seek to reopen the deal, increase their take, reduce the subsidies that they're offering you, or in the most extreme examples, expropriate your assets. And then the investor is left, having built a very expensive asset that it cannot pack up and take home, wondering how it's going to recoup its investment. And to address this, over many years, an international network of investment treaties has sprung up to give investors comfort that if the terms of its deal are not respected, it can have a direct claim against a state through the dispute resolution process that's included in the investment treaty for a damages claim. And you'll all be familiar with these claims, but broadly, the overseas investor brings a claim against the state for breach of the substantive protections that are in the treaty, which arise as a result of the state's unilateral conduct. So fair and equitable treatment standards, freedom from expropriation, protection from discriminatory measures. And historically, these treaties were seen as a way, I think, to mitigate emerging market risk. But as the energy market has changed, these claims, from the energy market's perspective, we're no longer looking for commodities in the ground, but exploiting wind, solar, hydro. So too have the respondent states in these claims changed, and we're all very familiar now with seeing, for example, European countries as respondents in ISDS claims. And in recent years, these treaties have come under some criticism as being stifling of the energy transition. Critics say that this closed shop, as they see it, are not fit for purpose in a 1.5 degree post-Paris Agreement world. So what has driven this? I think it's really two types of claims. First, the claims we saw that arose from the pivot to renewable energy, a wave of claims across Southern Europe after countries there changed their feed-in tariffs for renewable energy in the wake of the global financial crisis. Those tariffs became unsustainable and withdrawn, and investors who had relied on that subsidy regime brought damages claims running into the very many millions against Spain, Croatia, Italy. And the second type of claim more recently is what's been classed as stranded asset claims. So where states make regulatory changes which necessitate early closure of energy and power assets. We may have seen the claims that RWE and Uniper have brought against the Netherlands, for example, which come in the wake of the Netherlands phasing out coal-fired power stations. A similar claim was the one that Rockhopper brought against Italy. It had undertaken exploration offshore Italy for an oil and gas project, but ultimately wasn't awarded a production license because of a change in law there, which banned exploration and production along the Italian coastline. Rockhopper prevailed in that case, and one of the controversies that arose out of that was the measure of damages that is appropriate in these investor state claims, and I won't touch on that, that's Colin's area of expertise. So I think states are facing litigation risk on both fronts. If there's a misstep with how they regulate the renewables sector, they may be facing claims from renewables investors, but also as countries seek to decarbonise and phase out their reliance on fossil fuels, they may also face claims, stranded asset claims. And it's said that the threat of this type of claim is deterring governments from proactively regulating towards the energy transition, and that treaties are fettering states' rights to regulate for a better environment. And at a trade level, at least, there's recognition of this and a move to modernise some of the investment treaties, the aim being to promote and facilitate the energy transition. The Energy Charter Treaty, which is apt for today's discussion, being an energy-focused investment treaty with over 50 signatories, has actually been going through a modernisation process for the last 5 years. And two objectives worth touching on from a corporate perspective was the effort to phase out the protection of fossil fuels in the Energy Charter Treaty, albeit that that's only been accepted at this stage on an opt-in basis. And then secondly, to promote investment in renewable energies and to more clearly cover energies that weren't specified in the ECT when it was drafted, because they weren't really under consideration then, like hydrogen, CCS and other new energy technologies. The challenge is, particularly the multilateral treaty like the ECT, is that different countries are at different stages of their energy transition and have different interests when it comes to the energy trilemma of security, sustainability and affordability, and getting the necessary consensus to actually formalise any changes to this treaty is proving very difficult. And this lack of consensus has actually led to a number of European countries signalling that they plan to unilaterally exit France, Germany, Netherlands, Poland and Spain. The purported reason for that is that they see this treaty as incompatible with climate change, but equally a number of these countries are already facing extremely large damages claims, and there's some sense that they're looking to mitigate their exposure to these claims. But even for those countries who choose to exit, there's a 20-year sunset clause under the Energy Charter Treaty and similar clauses in other investment treaties, which would protect at least existing investments for the next 20 years. So the immediate impact of a withdrawal from the treaty may be fairly limited. At a macro level, I think my observation for the trade negotiators is that the cost of the energy transition is recognised to be absolutely enormous, and huge private sector investment is going to be required, and those investors will be looking for treaty or equivalent protection when they're considering the investments they make. So the real challenge for those negotiating these treaties is balancing those different interests with the country's needs to develop their climate policies to achieve net zero.
Thank you, Holly. Certainly a challenge in terms of getting that balance right, no question. But part of this all turns on the climate science itself, which we've touched on a little bit in terms of modelling. But as we come into the home straight now, perhaps Alex, if you can take us through some of the latest developments in terms of the modelling.
And I keep this relatively high level because obviously climate modelling. Can everybody hear me still, by the way, at the back? Wave the hands. Yeah. At all. Okay. I'm gonna move, if you don't mind. Actually go for that there. Is that better? Yeah, brilliant. Thank you. Okay, so I'm going to keep this quite high level because climate science modelling is an incredibly complicated subject, as you can imagine. The reality actually is, I'll actually take one step back. First of all, when we talk about attribution science, climate, it actually means different things for different people. So we have looking at blaming people for who's responsible for past climate change. Over 50% of the greenhouse gas emit concentrations we've got now occurred by the mid-1980s. So who's responsible for past emissions? Who should be picking up the bill for it? We then have extreme event attribution. In other words, an event's occurred, it's damaged my assets. Is that defendant there responsible in terms of their actions, their policies, etc., for subsidising or paying for a penalty for that damage? But we also obviously have what we talked about earlier on about scope 3 emissions. And fundamentally, they all overlap and they've all been evolving very, very quickly. Now, some people would say, actually, this is a bit of a novelty. Climate change science is a bit of a novelty. The first climate reports actually came out about 2003, and we're in London when a guy was watching the floodwaters of the Thames approach his front door, and he asked the question, who can I sue for this? Within a year, we had the first climate attribution paper and looking at basically the European heat waves where some 70,000 people were killed across Europe in 2003. Since then, if you go on Carbon Brief, I don't know if you're familiar with Carbon Brief, it's a website. There are 500 climate attribution cases you can see on Carbon Brief. We also have the Weather Attribution Initiative, which is a pan-European initiative of scientists who in real time are assessing climate change events and trying to attribute them as to whether it's actually associated with climate change or not. Now, there's a quick message there for everybody, and this is something that I'll come back to, in fact, is that actually not all climate events are associated with climate change or can be easily attributable to them. And there's a desirability or an overconfidence bias, whichever you want to say it, to assume that basically we have a flood event and therefore it's associated with climate change. That's one of the things you've got to be really, really careful of. Now, as lawyers and most of the people in the room, when you're writing pleadings, one of the big challenges is the question you're asking. What question are you going to take people to court on? It's no different in climate change. And in actual reality, if you ask the wrong question, you will get you'll get a different answer, obviously. And one of the big reasons why climate change cases have failed in the past is because the wrong question is being asked. Okay, you've got to really think about the question you're asking. And actually, when people are doing attribution assessments, they often actually ask multiple questions now. They no longer limit themselves to one question. But going back to the sort of what I talked about before, data uncertainty, model uncertainty, conceptual uncertainty. In 2003, they simply did climate simulations based upon the current climate, and then a model where basically you got climate associated with an anthropogenic component, and subtracted the two and said actually one's more likely than not. Since then, what they've actually done is in order to reduce that data uncertainty, in order to reduce that conceptual and model uncertainty, they now basically run multiple models. They do thousands of simulations, and it's done probabilistically. So if you go to, for example, the Weather Attribution Center, the result they give you is a probability factor. In other words, there is a 75% probability that this climate change event at 95% confidence has been even more likely or has been more intense. So again, courts are used to dealing with probability. That's a good thing. In order to calibrate those models, though, and make them more valid and defensible, you obviously need data. So one of the interesting observations again is that climate change cases in the global north, where we have long-term good records of data, where you've got the UK Met Office, etc., collecting lots and lots of time series data, are likely to be more successful because the models have got a higher degree of certainty in them than a model, for example, being delivered in the backwaters of unfortunate third world country where the records might not be so good. Similarly, way back in 2014, there was question marks about basically who's responsible for past climate change. And there was a paper by a guy called Heed, and he was one of the first people to do this. And he identified that I think it was about 914 billion tons of CO2 equivalent, should I say, could be blamed on 63 companies. So 90 entities, and they were responsible for 63% of all global emissions since 1751 to 2010. And it was the first time where actually attributed, instead of nation state attribution, they were attributed to individual organizations. Now that mechanism in doing that is becoming a lot more common. In the RWE case, for example, it's moved away from looking at nation state responsibility to actually individual corporations and entities in recognition of non-linear inputs, but also actually a lot of these guys work over multiple jurisdictions. So for example, in those cases, I think 43 of them were multi-jurisdiction. So you can't just go after Annex 1 nation states anymore. The idea is to go the actual individual companies, etc. So the key thing here really is that this is becoming incredibly common. The science is improving very quickly, but have I got time still? Okay, very quickly then. An interesting observation is that when you look at the paper on environment climate litigation by the Grantham Institute, they identified 2,000 odd cases, within which 232, they said basically 113 of them were successful. So roughly only 50% of them were successful. There was a paper done by Durham University in 2021 that looked at 73 cases across 14 different jurisdictions. And they found some quite shocking, in my mind, results. Now, as lawyers, and if I was going to you guys as lawyers, first of all, if my case is going to be admissible and standing, it's got to be based on some form of evidence. 73% of those 73 cases that were assessed at Durham University didn't actually refer to any form of peer-reviewed articles or papers on climate attribution. So they went there with very little science. I think 54 of them, don't quote me on the precise numbers, 54 of them actually couldn't identify a causal link between the damages that were being claimed and the defendant's actions or policies. So they weren't even getting over the first hurdle of causation. There was no causal link. The next thing that was happening was there's an overconfidence bias or a desirability bias to automatically assume that this event can be blamed upon climate change. Now, as I said before, climate events occur for multiple reasons. And for example, if you're looking at sea level change, I think something like 36 of the cases they looked at were about sea level change. The thermal expansion of the seas is non-uniform. Bits of the world are going up and down. Scotland's rising, south of England sinking. So climate change based, so when you're looking at sea level rise, you've got to account for local effects. And it's the same in all these different parameters. If we're looking, for example, at, I'm just giving a random example, flooding. In 2017, Bangladesh flooding affected whatever it was, 7 million people or whatever. They couldn't attribute that to climate change because in Southeast Asia, we have lots of sulfates in the atmosphere that can offset, and the data wasn't good enough. So you can't just automatically assume that it is. So, but I think what's actually happening is the evidentiary gap in science is being filled. But what's really interesting is in the last few years, a lot of these court cases, for whatever reason, have failed to employ the right experts to use peer-reviewed case studies, and as a result, they've fallen over. But I think going forward, and I think it was one of the comments that Catherine made earlier on, this is a trend that's not going away, and the science is building, and it's building exponentially. So I do think you're going to start seeing more cases now. You start seeing more cases that are going to be successful. But as lawyers, make sure you're using state-of-the-art science. Don't ignore it.
Thanks, Alex. And I'm sure there's plenty more to go on later. But more cases and more success means there's going to be more questions around quantum damages for those cases. The valuation at the end as usual. Now, I've talked about this for a few years, seeking to answer the question about what we're doing as damages experts to reflect climate change in terms of valuations. And initially, I would say that I would flag that we follow valuation generally, and that the valuations were not yet showing any specific ESG adjustment. I know some valuations reflect ESG issues, but I mean a specific adjustment in evaluation. Last year, when we were at LUW, I flagged the work of Accounting for Sustainability Valuation Framework. As a quick reminder, they, backed by some of the world's largest investors, proposed 5 stages to incorporate climate change considerations. Identify the company's key value drivers, assess the source of climate change risks and opportunities, filter those climate change risks and opportunities for those that are more significant and more likely to occur, integrate those into the chosen valuation approach, and triangulate the identified risks and opportunities for the market and iterate as required. Needless to say, that's a lot more complicated in practice than it sounds when you just read out a list of 5 items. But it has helped to take the debate forward. Where I'm going today, though, is the most recent area that I've seen, and I think some potentially very significant development, which is the changes that are proposed to to the international valuation standards in the current exposure draft that have been put out in April 2023. We were talking before the session started about securities litigation and the fact that almost all securities litigation ties into some form of ESG failure. Well, what's interesting in terms of the valuation standards is that part of the reason for the new proposed standards was stated to be the need to address new types of assets and liabilities, including environmental, social, and governance factors. And under these new standards, ESG considerations would permeate the whole valuation process in relation to the scope, the reporting, and the specific valuation considerations. So if I look at each of those quickly, firstly, defining the scope of work for the valuation. There's now a requirement under the draft proposals to define in the scope of work for environmental, social, and governance factors any requirements in relation to the consideration of environmental, social, and governance factors. That's going to require valuers to consider such points from the outset, and in itself it may change the way some valuations are put together. Then when it comes to reporting, there's an added clause for what must be included in a valuation report. It simply says environmental, social, and governance inputs used and considered. But that one line could mean huge numbers of pages that are actually sent out, or it could mean that people say very little, but that in itself could raise questions about how reliable the valuation report is. The fact that the report actually has to specifically state the ESG inputs that are used and considered will, I think, make valuers focus far more on what inputs should be brought in. And certainly when it comes to damages valuations, I expect that to be far more of a back and forth discussion. The third area then gets into the specifics of the different valuation approaches. So a quick reminder that the two main approaches that we typically use are market approach, assessing value by comparing against comparable companies or transactions, and the income approach, assessing more directly on the expected future income of the company or business. Now, for the market approach, when considering how comparable a particular company is, there's now a specific requirement to consider adjustments for differences in ESG considerations. That wasn't specified before. In principle, you may say it should always be implied, but if you're looking at comparables, you have to consider how comparable they actually are. But again, what this now does is to shine a light specifically on this issue. And that, I think, will lead to more discussion of the ESG differences between companies. Then for the income approach, there are actually three main elements if you're performing the most common DCF valuation: the cash flow projection period, the termination value for the period after that, and the discount rate. In the standard, in the draft, it talks about termination value, which can often be a very significant portion of the overall value. And it specifically says that there is a need to look at the risks and opportunities associated with environmental, social, and governance characteristics of the subject asset. Wasn't there in the previous standard. So that's going to require consideration long term of what will actually be realistic to expect, given the characteristics of the asset. So areas such as coal in particular, but oil will probably face those questions as well. Now, interestingly, I don't see the discount rate flagged in the same way in the 2023 draft. There isn't really a consensus within the valuation community as to what extent such additional environmental risks should be reflected in the assessment of discount rate. But there is some strong empirical evidence of discount rates varying between 10 and 11% for wind and solar assets, up to 40% of times for investment in coal assets. I'm not saying that's purely environmental related, but there's certainly a significant factor within that would be. And it wouldn't surprise me to start to see an ESG premium or discount starting to be applied as people in their valuations have to be more explicit in terms of how they're taking such matters into account. So just in terms of the direct valuation issues, there is a specific appendix on data and inputs related to ESG factors. It says that the valuer must be aware of relevant legislation and frameworks in relation to the environmental, social, and governance factors within their valuations. Now, I emphasize must, because that's quite an obligation, it's quite a broad obligation. What's going to be relevant? Is it legislation that's outside the specific territory as well as what's in there? So I think there are a whole bunch of questions that will need to be unpacked in terms of where that goes forward. And it says that valuers must consider significant ESG factors. And it gives some examples of those. So environmental, we hear more about typically. Climate change, current and future risks, carbon emissions, natural disaster, but it also lists resource efficiency and waste management. And these are a non-exclusive list. These are examples that are good. It then goes on to talk about social factors. So the valuers are having to now look to build in issues around equality, human rights, working conditions, and data protection, amongst others. And finally, examples of governance factors. I think there's a few in particular that could prove controversial in a dispute sense. With bribery and corruption, donations, ESG reporting standards and regulatory costs, and political lobbying all being part of that list. Given that bribery and corruption has already been a growing trend being argued in some of the cases, especially the investment treaty side, I think that argument may now be moved more into the valuation arena as well. So you've got some very broad questions that are being thrown at valuers in a way that haven't been done before. Those values then come out in corporate reporting, which leads back to some of the discussions from a corporate point of view, which we'll come back to maybe in questions in a second. The standards are under consultation, so obviously they may well still change. And whatever comes in is going to apply not until at least July 2024 formally, although corporates could choose to apply it earlier. But I think it's clear that whatever finally comes out, key point is that it now looks highly likely that all three forms of environmental, social, and governance issues will need to be considered explicitly in valuations under the new standards. I think that will drive us to greater particular adjustments for some of those. The one final point I would just make though, from a disputes point of view, is it's worth remembering that for damages, many of our valuations are based on dates in the past. So it may still be under the prior approaches. It's only when we either have a recent valuation date or we're looking out into the future and the future expectations under different scenarios that will need further consideration. So that concludes our presentations. And now I wanted to open up to, if there are questions either in the room or online, we do have the facility to receive questions online. So I'll open that up to you. And if not, then I do have a couple for myself. But first of all, has anybody else got questions? Yes, at the back of the room. Sheila, come on.
I believe that's me.
It is, yes.
I will caveat this. My name is Kat Rosenbaum.
Let's just give you a microphone.
Thank you. My name is Kat Rosenbaum. I head up client relations with Radis, which is a business intelligence firm. I caveat this as a former lawyer by saying that I did miss part of the presentation and some of it was very difficult to hear. However, about five days ago, client Earth versus Shell was dismissed by the English court. And I'm not sure if the panel has talked about this case at all or not. But one of the considerations and one of the weak spots was the lack of expert evidence in client Earth submissions, i.e. they had a client Earth lawyer applying on what the degree of environmental damage was. Given what I did hear from the panel, do you think that's a trend we should be watching for in terms of kind of the novel way of bringing a potential claim, but also coupled with stronger expert evidence that we might actually see results in this sort of litigation going forward? Thank you.
I'm happy to kick off. I don't know at which stage you arrived, but one of the themes of the short section that I dealt with relatively early on was the growing trends of people being able to bring claims here. Many of those claims, of course, are being heard at early stages, so dealing with jurisdiction, claims trying to strike out. I touched on a case where there was a question of abuse of process, And of course, there are issues such as evidence available, and that of course brings in the expert question, which we'll perhaps touch on again in a moment. I think what we'll see is that over the next 5 years, claimants will be relatively well funded, both in the private sector of litigation funding, but also in the public sphere and the non-governmental sphere, where we'll see NGOs funding claims, and a lot of these will be relatively speculative. They'll be speculative because it is difficult to get claims off the ground and bring them in the jurisdiction where you can find the deep pockets, various reasons. But nevertheless, I think these claims will begin to sound in damages. So the type of issue you touch on in the Shell case, I think will be worked through over the next 2 or 3 years. And I wouldn't be surprised if we see an exponential curve as the claimants in those type of cases learn lessons from perhaps the mistakes or the difficulties that certain claimants have already experienced. But in the expert sphere,
I can you guys hear me at the back? Yes, apologize again. So I totally concur. I do believe that what's just been said in the fact that the data is getting better, but I do feel that for whatever reason, a lot of these cases have been taken to court without traceable evidence from party A to party B, when actually that evidence was available and or could have strengthened the case. So I think I'm talking from an expert's perspective, and I'm not talking from a funder's perspective, but in actual reality, if you're going to run with one of these cases, you need to front end load your case with expert knowledge so that you can actually get over that admissibility hurdle, that standing hurdle, so you can actually get to substantive evidence. And a lot of the documents that have been reviewing the climate litigation cases have concluded that a lot of them aren't simply getting over that hurdle, because what they're doing is they're being a bit speculative, as George is saying, and it's very easy for somebody like me to come along and turn around and say, that's far too speculative. You haven't proven a link between party A and party B, and therefore it doesn't get for admissibility, and it's gone, and you've wasted your time. So if you are serious about these cases and or defending these cases, you need to engage early. Because actually as well, climate attribute, depending on the complexity of it, certain climate attribution topics, we're more confident than others. So heat waves, anything to do with drought and heat, it's pretty well good known science. Something to do maybe, for example, with tropical cyclones, etc. That's a little bit more complicated. But attribution studies can take time. So it's also something that you just don't go out. It's not just sat on a shelf waiting for you all the time. Sometimes it is, but actually you need to actually engage early. And I do think that, as George said, we're going to start seeing, or we should start seeing, if you want to fill that evidentiary gap, we're going to start seeing that in the next year or two.
So you've got to approach HK very early on, really.
Yeah, basically approach, yeah.
Give me a call.
Make a note.
But it's yeah.
Catherine?
I was just going to say, when it comes to litigation in the public sector, when you're challenging a public body decision or a central government decision, and they are taking decisions that are based on expert evidence about climate change issues, the courts generally take the position that they don't want to hear expert evidence in the public law arena. And if the government has an expert opinion that they're relying on, that's a reasonable opinion, even if it's contested by another equally reasonable expert, the court's not going to gainsay the expert that's been relied upon by the public body. And I wonder, in an area which is potentially quite contestable, when there are different models you can use, different data you can put into it, and there's a reasonable view to be reached as to the data you select, the model you select, the certainty threshold you adopt. When it comes to challenging certainly public body decisions, it's very, very difficult. And I think that would possibly translate into when you've got claims, like we're seeing claims in other jurisdictions, challenging claims made by companies on the basis that they're greenwashing, or indeed a recent claim that's been launched in France challenging Greenpeace. I think it's sort of equivalent to a libel action. Greenpeace claims that Total have inaccurately reported their ESG position is being challenged. If either side has an expert that supports its position, it's going to be very difficult to make good those claims. So question for the expert, how
a lot in that question. I think first of all, different jurisdictions obviously have different I suppose bars of what is traceability and what is the standard they're expecting. And that's one of the issues. But I suppose really the term fairly traceable is the first question. Can we fairly traceable? So can we fairly trace the actions of party A to a given event or to a given piece of damage? And that's one of the first questions. And that's the thing that's been lacking to date. Not in the scientific world, but it's not been taken to the court in a lot of these cases. That's one of the findings of Durham University, and again with the climate change reports of Grantham Institute. So it goes back to simply making sure that you've got an appropriate burden of evidence. But the difficulty is that, as I mentioned before, science is not a perfect art, and we have conceptual model and data uncertainty. The scientists have been reducing that by looking at all these different models and simulating them, but there is a consensus of approach which has been evolving. So, for example, the guys at the Weather Attribution Initiative have got a peer-reviewed approach for looking at attribution, and they're using that approach and turning around attribution assessments within 2 or 3 weeks on occasion, or even when the event's actually unfolding. So the science is going on leaps and bounds. It is an exponential curve. Undoubtedly, though, when you get 2 experts, we all know that the reports are meant to be the same no matter what side of the table you sit on, but the reports never are. It's a fundamental part of just the system that we work in. But when we get into a situation like that, there will be a consensus in terms of approach, in terms of the modelling. There are certain tools out there which are, the idea is to use multiple tools, but the idea is that you get an envelope of uncertainty. And I think what the argument would be about how uncertain, what parameters have been put into that model to generate that degree of uncertainty. And it's quite easy to throw stones. So just as an example, if we took the sea level change, in 300 years, there's talking about massive instability of the West Antarctic ice sheet in Greenland. That also results in a massive tipping point. Now, if we're going to develop infrastructure, an oil rig or a nuclear power plant or a nuclear repository, those are the timelines we're talking about. And I've sat on panels and I've been advising UK policy and government and nuclear power plants, etc. The reality actually is, do you want to actually now start planning and designing for something that may or may not happen in 300 years' time when there's scientific uncertainty? And that's the kind of decision that's starting to come into planning decisions as well, because when we're starting talking about, for example, future intergenerational burden, which is a crossbench policy currently also within the UK, it's already in Wales, where you're talking about basically making people pay now for things that are going to happen in the future. The activist organisations are going to jump on that in planning applications and saying, if you build this now, how are you going to account for uncertainty in 300 years' time? The uncertainty factors grow as you go further down the timeline. And I think that's where you're going to start seeing the nation state challenges and the big planning challenges. And that's where the debate's going to occur. I think the debate's going to occur less on extreme events, more on long-term planning issues. I don't know if that answers the question. Probably doesn't actually. Does answer.
Any other comments on this one? Okay. Any other questions that people have got right now? Otherwise, I wanted to pick up the greenwashing one. Sorry.
Yeah, my name is Michael Lightfoot. I'm associate with Charles. Just on my attribution and problem causation, I was wondering what you might think about using a wider concept of strict liability, whether it's in different jurisdictions. My experience, for example, in the US, where you have strict liability regime for defectively manufactured products. I just wonder what you think about expanding that kind of theory for duty of care and causation as a way of getting over this attribution problem, particularly in litigation between 2 private parties.
Did you want to start it off and then maybe Joy?
Yeah, I can't confess I've ever given that any thought. I mean, certainly it's something that you see in the environmental space over here, that there's effectively a strict liability regime. But I think that the difficulty with translating that into the climate change contribution space, you still come around to a causation or an attribute, what liability you're actually attributing to the individual defendant. That from my perspective, there still need to be some kind of measure of that defendant's particular liability, even if it is in fact strict. You do have any more intelligent thoughts on it?
I think what you're driving at is there's going to need to be some sort of policy intervention here, because there are almost insurmountable causation issues. And we see that in the planning context at the moment, when you're looking at applications for big infrastructure projects like road schemes or airports, you have to assess the cumulative impact of your greenhouse gas emissions. Everyone said, well, you know, this is the contribution of our project. Does that then mean that we're going to exceed national level? Well, we, you know, don't know, because it all goes into the air and it's indistinguishable from what other schemes are, you know, contributing in other parts of the country, let alone other parts of the world. And I'm not sure that it's an issue of sort of science or attribution. It's an issue of the government stepping in and saying at a policy level how we're going to deal with these cumulative impacts. And I mean, I think strict liability, another way of looking at it from a different lens, would say this is going to be a tax on emitters. You have to pay a certain amount if you contribute a certain amount of emissions.
Yeah, no, nothing particularly to add to that. It's just because I think we're going to see different types of claims, as I was saying earlier, and that's where you may see different angles, nuisance claims increasing, etc. But no, nothing to add to that.
I mean, I guess going back to the kind of government change, the courts over here, at least, and courts in different jurisdictions have taken different approaches, but our courts, or the civil courts at least, have, you know, given indications in the judgments that they see a number of these issues as being policy issues rather than issues for the court to determine. You know, the extent to which the government is reading these judgments, I don't know.
I think it's the hot potato. Yeah, I mean, who wants to have to grapple with this? But yeah.
Can I comment? I think if you go back to the paper I mentioned, which was the Heed paper in 2014, which was one of the first papers about looking at responsibility. Obviously, it was an academic exercise, and they identified 90 entities that were contributing more than 8 million tonnes per year carbon equivalent, and they identified that they were responsible for 63% of the entire global greenhouse emissions, as I mentioned before, from 1854 to 2010. But that paper arose in terms of its context and the fact that way back in 1992, when the IPCC were having the first conversations, when they're talking about responsibility, who's going to pay for all of this? The idea was that Annex 1 nations were going to pay for it. In other words, they were going to take liability fundamentally, simply because they benefited. In other words, those countries have done well. That wellness is associated with energy use, and that energy use therefore reflects the fact that they should take accountability. They argued, bizarrely, I digress slightly, they argued that they didn't know about climate change until 1990, and therefore they didn't want to take any liability for anything prior to 1990, which is a little bit tenuous in my mind, but putting that to one side. But the idea basically being is that the guys that have been responsible, you know, the concentrations we're seeing now might not be the same nation states or even the same polluters that we have now. They might not exist anymore, or they've moved on, or the technology's changed, etc. So one of the interesting issues is that instead of moving it to nation states, was to actually look at sort of a strict liability type regime for the actual producers of the material. Hence why it went towards looking at individual organizations. Now, I'm not, in Glasgow, just whenever it was a year and a bit ago, there's still huge arguments about who's going to pick up the bill. It's not going away. I'm not a politician, and it's way too complicated for today's conversation. But it is an incredibly difficult conversation that is going to only continue to evolve, because nation states can turn around and say, we can't be held strictly liable for this, because actually the companies that did this have actually worked over multiple jurisdictions, and we have non-linear commitments as well. In other words, it's not just a simple matter of saying we've got GDP, if this has resulted in that. Certain countries have emitted more because of the kinds of products, etc., they produce. So I do think that there's going to be a move towards looking at, potentially people are talking about that sort of equity share, strict liability model. And the activist organizations in particular are looking at the big, the big oil and carbon producers in the aviation industry, because they're the obvious targets. And I think that's going to be a trend. They're going to keep going for the big players, the guys who have been partially responsible, and saying, you're part of the problem, you need to start remedying it, and we're going to push you for strict liability on it. But I think it's going to vary, as I say, by policy globally and what the policies are in those different jurisdictions. Don't know.
Yeah, I mean, as an environmental scientist in a financial organization, it's not really up to me to make political commentary, but it would be a bold government indeed that decided to legislate for strict liability and kind of open up the courts to a raft of claims that would I think dwarf what we've seen to date. And you know, do I see the political will in any party to take those steps? There's not much evidence of it.
Any other questions that we have?
Hi, Jack Trissino, I'm a partner in Freshfields. You were talking about ISDS and some of the changes in the energy treaties like ECT and states, some of the states that are pulling out of those and changes, the modernization changes we're looking at. We're also seeing some new treaties where states are trying to introduce effectively an environmental carve-out, similar to the tax carve-out. We've seen a lot of treaties to give them the ability to pass environmental legislation without it succumbing to the protections that investors are otherwise given under the treaty. And I'm just wondering if, you know, if you're seeing a lot of that, if you expect that to be a future trend, or if it's just kind of a passing phase.
I mean, I don't, you know, advise on the drafting of these treaties, but I don't see how it can be a passing phase. I think it's a shift, a permanent shift that we can expect to see, because, you know, states have signed up to their Paris Agreement commitments and they have to get to those commitments in some way. And it's, you know, going to take a lot of political will internationally to do that. And one of the steps they can take is to, you know, be able to enact policy that promotes the pathway to net zero. And I can't see why states would stop asking for that to go into their investor state treaties, unless they're finding that there's real pushback from investors, and, you know, they see the investment start to tail off. But the story that we're hearing is, you know, there's plenty of capital out there for green projects and people looking to invest. So, I mean, I suspect it's probably a permanent shift. I think the real challenge with the ECT, of course, is, you know, it's the multiplicity of parties involved. I think when you're looking just at bilateral treaties, the changes are going to come through more quickly.
So on conferences I've been at with UK government lawyers and lawyers from other European jurisdictions, the mood music is that this is the move, certainly in the European sphere. I don't have any direct experience of it, but that's what I'm hearing.
And I'd just throw in one thing in terms of that. It's not just the governments themselves, you know, making a free choice anymore, because you do have the Friends of the Earth, Client Earth, and an increasing number of other organisations that will take action against the government to force them to review what they're doing if they're not actually acting in a way that those organisations consider. So there's that extra level of pressure sitting behind them. But apart from the normal ballot box political pressure, that I think will also means they have to keep considering that even more.
Yeah, I mean, certainly you're seeing challenges to the regulators from the NGOs to be more active in the way that they're regulating financial markets and other markets.
Any other questions? If not, then I will just say thank you to our panel. Very good to actually run through all of those issues. I'll ask you to give us people here a quick round of applause, and then we can adjourn and enjoy the terrace.